Welcome to the Equal and Inclusive Housing Knowledge for Stakeholders webinar created by the DC Office of Human Rights. My name is Elliot Imse. I am the Policy and Public Affairs Officer at the DC Office of Human Rights.
And I am Akita Smith-Evans, Lead Fair Housing Investigator with the DC Office of Human Rights.
Akita and I will be walking you through some general information about fair housing, including local and federal laws, that will hopefully help you in your work on behalf of marginalized communities here in DC and nationwide. Housing discrimination was an important component in equality movements throughout the 20th century and earlier. 45 years ago today, President Lyndon Johnson signed into law the Federal Fair Housing Act of 1968, a landmark bill that is the foundation for preventing housing discrimination today. The act was signed into law only 1 week after the tragic assassination of Martin Luther King Jr., whose death sparked Congress to push forward the bill. Dr. King had made the Fair Housing Act one of his biggest priorities in the years before his death, and the DC Office of Human Rights is proud to continue that tradition today. With the passage of the Fair Housing Act of 1968 and its amendments, and local commitments to affirmatively furthering fair housing across the country, we've made a lot of progress. But despite these strides, housing discrimination continues and remains a critical issue for marginalized populations. The right to choose where we live affects our employment and educational opportunities, proximity to friends and family, access to transportation, commercial and government services, and even our personal safety. We are excited to have you join us today because it's important that we incorporated housing discrimination efforts into our work of social justice and civil rights. We hope this webinar keeps you engaged. We've added some interactive elements to hopefully do that. And we hope it will assist you in your work. We encourage you to learn more about fair housing on the DC Office of Human Rights website, ohr.dc.gov, and on our Facebook page at facebook.com/DCOHR. To start off, we're going to take a quick poll to gauge your level of knowledge about fair housing issues. Please mark one of the following options. That you have expertise in fair housing, that you have a good understanding of fair housing, that you have an average understanding of fair housing, or that you have a limited or no understanding of fair housing. We'll give you a few moments to answer. We'll show the results, and hopefully that will gauge us in the slides ahead. Just a few more seconds. We still see some answers coming in. Yeah. All right, and we'll show the results. We'll show the results right now. All right, that's excellent. It looks like we have actually fairly diverse participants, which is exactly what we'd like. So we'll carry on with the presentation and hope you enjoy. Remember that at the end there will be an opportunity to ask questions of both Akita and myself. Just quickly, this webinar is funded by the U.S. Department of Housing and Urban Development, or HUD. HUD's mission is to create strong, sustainable, inclusive communities and quality, affordable homes for all. In relation to fair housing, HUD works to build inclusive and sustainable communities free from discrimination. The Office of Human Rights, that's us, or OHR, works closely with HUD to investigate complaints of discrimination and on many other fair housing issues. So we're going to talk about the Office of Human Rights, where Akita and I are from first. Our mission is really to eradicate discrimination, increase equal opportunity, and protect human rights through enforcement of district and federal non-discrimination laws. While OHR does proactive advocacy work to prevent discrimination before it happens, really the primary function of this district government agency is to investigate complaints of discrimination that are filed with the office. These complaints can come in the areas of housing, employment, public accommodations, which can mean anything from restaurants or stores or buses, and also educational institutions. For housing complaints, which is of course the focus of our talk here today, OHR relies primarily on two laws. One is the DC Human Rights Act of 1977, which is one of the most progressive non-discrimination laws in the nation, if not the most progressive. And also the Federal Fair Housing Act of 1968, which I mentioned earlier was signed into law today, partially because of Martin Luther King's tragic death. So really quickly, almost anyone can file a discrimination complaint with the Office of Human Rights, from individuals to organizations. It can include group homes, advocacy and fair housing groups, as well as real estate agents. A complaint can be filed as long as the person suffered an actual or threatened injury of discrimination. The respondent, or in most cases for housing, the housing provider, does business in D.C. The complaint can be filed as long as the subject matter is covered by the Fair Housing Act or the D.C. Human Rights Act. And the complaint needs to be filed within 1 year from the date of the last incident of discrimination. A benefit of filing through OHR is that the person or organization alleging discrimination is provided a cost-free complaint process that does not require a lawyer, allowing individuals from diverse socioeconomic statuses to be provided an opportunity for their claims to be heard. This is something we're really proud of at the Office of Human Rights, mostly because a lot of people that are discriminated against cannot afford a lawyer. We're really proud that we can offer these people potential justice despite them not being able to afford something such as that. So to file a complaint, individuals can fill out a simple complaint form online or by visiting the OHR office at the Judiciary Square Metro stop here in D.C. That's on the red line. After filing the form, they may be brought into the office for an intake interview where an investigator will attempt to find out more details about the alleged discriminatory housing incident. After the intake interview, OHR decides whether it has jurisdiction over the complaint, and if so, will formally accept it as an official OHR case and cross-file it with the U.S. Department of Housing and Urban Development if it encompasses protection under federal law. Once a case is accepted, the office will initiate an investigation and schedule mediation between the complainant and the respondent, who's the person who allegedly discriminated. OHR is actually really unique in that the mediation is mandatory for both the complainant and the respondent. Both parties must sit down with an OHR mediator and attempt to resolve the issue with an agreement that can include anything from obtaining the desired housing, monetary damages, required staff trainings, or other solutions that are brought up during the mediation. If a mediation settlement is agreed to, the investigation stops and the case is closed. However, if mediation fails, OHR will continue to investigate the case until it is complete. The investigation may include interviewing the complainant, respondent, and witnesses, a review of documentation and policies, or other methods. Once the investigation is complete, the investigative report is sent to OHR's General Counsel for review and legal analysis of the investigative findings and forwards it to the Director for a final determination. The Director of OHR, Gustavo Velasquez, then reviews the determination and decides whether to render a decision of no probable cause or probable cause. If probable cause is found, the parties will meet for conciliation to try once more to reach a mutual agreement. But if no agreement is made, the case is sent to the D.C. Commission on Human Rights. There, one of 3 administrative judges will review the evidence and make a legal determination about whether discrimination occurred. Explicit damages will be recommended if discrimination is found. A panel of citizen commissioners appointed by the mayor then review the judge's finding and either agree with the finding and damages or overturn the finding or demand different damages. And really, it's the commissioners that make that final determination. So now we'll shift gears from talking about the OHR complaint process to really talking about the D.C. Human Rights Act. And we promise you that we'll have a few videos coming up to keep you interested, as well as more of those polling questions. So make sure you pay attention because we're going to be quizzing you in a little bit. The D.C. Human Rights Act of 1977, which is one of the most progressive non-discrimination laws in the nation, as I mentioned earlier, bans discrimination in housing, which we're talking about today, employment, public accommodations, and educational institutions. Really, the reason we consider the D.C. Human Rights Act to be one of the most progressive non-discrimination laws in the nation is because it provides protections based on 18 protected groups, compared to only 7 in the Federal Fair Housing Act. The ones included under the Fair Housing Act are race, color, sex, national origin, religion, age, and disability. Those not included under federal law, but protected under the D.C. Human Rights Act, are personal appearance, marital status, sexual orientation, gender identity or expression, familial status, family responsibilities, matriculation, which is really status as a student, political affiliation, source of income, and this is often, such as the use of housing vouchers is often considered a source of income, status as a victim of an intrafamily offense, and place of residence or business. We're now going to look at the protected group status as a victim of an intrafamily offense a little more closely. Because status as a victim of an intrafamily offense is protected in D.C., it is now prohibited to refuse to make a reasonable accommodation in restoring or improving security and or safety measures for a victim of domestic violence. It's prohibited to prevent a person from terminating a lease early or with a penalty if they are a victim of such an offense. And it's also prohibited to bar or limit the right of a victim to call the police for emergency assistance or to impose a penalty for calling for emergency assistance. Status as a victim was added just a few years ago and is really an important addition to protecting victims of domestic violence here in D.C. The bottom line here is that in the area of fair housing, D.C. law is much more comprehensive than federal law with our 18 protected groups. This means that whether you're a tenant or a homeowner, whether you're applying for a loan or applying to rent an apartment, you are legally protected from discrimination under 18 different characteristics. So we promised you videos, and here comes the first one. We're going to watch a video showing an example of a discriminatory incident based on national origin.
Good afternoon, Parkside Apartments. Mr. Belmont speaking. I'm my assistant.
Hi, yes, Mr. Belmont.
Is Mr. Gomez from apartment 111?
Yes it is.
Alright, look, I have an issue with you people keep calling here asking for repairs to your apartment. We have explained to you that we don't do business like that. What's the problem now?
Well, the problem is that I reported a broken sink and garbage disposal over 5 weeks ago and nothing's been done about it. And coincidentally, my neighbor who reported the same issue got hers fixed right away. And I'm kind of wondering why there's some differential treatment here for what seems to be like individuals who aren't Hispanic who are getting repairs fixed immediately.
Look, you'll get your things fixed when we can do it. Don't call us again, or we'll be forced to evict you.
You can't do that.
Oh, we can't? Watch me. Keep causing problems to see what will happen.
Okay, look, I don't want to cause any more problems. I just want to get my sink fixed. Could you please just let me know when you'll be able to come up and do it?
When we get to it.
Oh!
Hey, Mr. Belmont, how you doing?
Hey, how you doing, Miss Vicky?
All right, my garbage just broke this morning. You think you can come by and fix it?
Sure, no problem. You can go get my tools and we can get on it right away.
Great, thank you so much.
So I'm sure the dramatic music in the background showed how serious a matter this is. But it actually is something that really affects the lives of many individuals and is more common perhaps than you'd think. So given that example of discrimination based on national origin, we're going to move on to another poll, and it's about the protected groups. Like I said, you just saw one based on national origin, and we've talked about how there are 18 protected groups in D.C. So our question to you, as a little pop quiz, is which of the protected groups below is not covered under the D.C. Human Rights Act? The four options are personal appearance, status as a veteran, race, or familial status. So feel free to answer now, and we'll see how you all do. Responses are still coming in. Just a few more seconds. And we'll show you the results here. So it looks like the majority of you do remember that status as a veteran is not covered under the D.C. Human Rights Act or federal law. It is covered in some jurisdictions. Personal appearance seemed to be the one that caught the second number of responses. And I think D.C. is actually pretty unique in including personal appearance amongst its protected categories. But it's one that we do see in front of the office a decent amount, both in housing and employment. So, again, the correct answer is status as a veteran that is not covered under D.C. law. So now I'm going to pass this webinar over to my colleague, Akita Smith-Evans, who I can't say enough about. She, again, is our lead fair housing investigator here, an expert on this topic, and she will be going in more depth into the Federal Fair Housing Act that we talked a little bit about earlier.
Thank you, Elliot. I appreciate that nice introduction. Now we're going to get more deeply into the Fair Housing Act, as Elliot has mentioned. The purpose and intent of the Fair Housing Act was to promote equal housing for not just some, but for all. When we think about the Fair Housing Act, it's very important to remember its context. When the Fair Housing Act was passed in 1960, segregation was rampant. Brown versus Board of Education had only passed a few years earlier. And in many states, they still enforced the Jim Crow laws to maintain segregation. When passed, the Federal Fair Housing Act originally only covered race, color, national origin, and religion. The Fair Housing Act was later amended to add sex as a protected group, and again amended to add disability and familial status as a protected group. The Fair Housing Act is very broad. It prohibits discrimination in virtually all areas of housing, from refusing to rent, financing, denying or limiting services, or imposing different terms and conditions based on one's protected category, such as your race, your national origin, or your sex. Now what we're going to do is show you another video. This video pertains to refusal to rent, in this case based on religion. Let's have a look.
Hello.
Hi, how are you?
I'm fine, how are you?
I'm doing well, thank you.
I saw your advertisement across the street for a condo for sale.
Yes, we definitely have a condo for sale. Let me get you to fill out this guest card.
Sure.
It's a beautiful unit. Perhaps you can take a look at it today and give the board president a call.
You are.
Thank you. How do you pronounce your name?
Afia Muhammad.
Is that a Muslim name?
Oh, yes, it is. Why do you ask?
Well, to be quite honest, we don't have any Muslims in this condo, and there are no mosques in this area. Actually, I forgot. There was a contract put on this condo last week. The board was impressed with the couple, and most likely their application will be approved. Are you sure you want to apply?
Well, if you think I have a good chance of getting in.
I think you should wait till next week. Give us a call back to see if the contract was approved. Because quite honestly, Ms. Ahmed, I don't want you to...
Muhammad.
I'm sorry. Ms. Muhammad, I don't want you to waste your time. If you want to submit your application, here's our checklist. Just be sure to submit your U.S. passport and your voter registration card.
Okay.
So now, as you all can see from this video, even though the representative was being very nice and polite, she gave those subtle hints of discrimination, and she made an assumption based on this complainant's or this particular applicant's last name, and assuming that she would be more comfortable somewhere else. And even though sometimes representatives may try to look in your best interest, it's not always in your best interest. They are intending to discriminate even more. And we'll see more of that later on in the presentation. One type of housing discrimination is blockbusting. And blockbusting is what happens when a real estate agent persuades an owner to rent or to sell their property because a particular group of people are moving into the neighborhood. For example, if the neighborhood is predominantly white and the real estate agent convinces the owner to sell their home at a reduced price because a protected group, such as Hispanics, are starting to integrate the neighborhood, this would be considered blockbusting and is illegal. The real estate agent may use stereotypes about Hispanics to convince the owner that the diminishing value of their property is inevitable. Another example of housing discrimination is called steering. While steering is very common, it may be done in a subtle way to make the buyer feel as though the agent is looking out for the best interest of the buyer when the intent is to discriminate. For example, an agent tells a couple with a child that the homes across town would suit them better because they have lots of parks, playgrounds, and plenty of places for children to play. However, the couple is only interested in homes in a certain part of the town, but the agent insists that another area of the neighborhood is better without even bothering to show the couple the houses that they have requested. It might not appear on the surface that it's discrimination, but this could be a form of discrimination. This couple with children should be able to live anywhere they choose. It should be based on their qualifications and not on their protected categories. Here's a quick example of a video of steering.
Hello, my name is Veronica, and I'm here because I saw your advertisement for the 2-bedroom apartments.
Well, welcome. My name is Tara, and I'm actually the leasing manager. We have a few 2-bedroom apartments available. Do you have any children?
I do. I have a 7-year-old son.
Okay. Well, what I'll do is I'll actually show you the unit we have coming available on the first floor.
Oh, well, I'm sorry. I believe you said you had a few coming open. Could I see all of them?
We do. However, we only rent units on the first floor to families with children.
And why is that?
Because children tend to make a lot of noise and they disturb people on the floors below them.
Okay, well, that would not be a problem. My child is very well behaved.
I'm sure she or he is, but that's just our policy.
Okay, well, I have a son again, and could you tell me a little bit about the amenities here?
Excuse me for a second. We actually, each unit comes standard with wall-to-wall carpeting. We have newly refurnished kitchens, and there's a laundry facility in the basement.
Okay, a pool. I believe I saw an advertisement about pool.
We do have a pool, but that wouldn't apply to you. At this point, we've restricted children from using our pool because they splash a lot and make a lot of noise and disturb the other residents.
Wow, okay. Well, thank you for your time, but I do not think this is going to be the right place for me and my family.
I totally agree, but thank you, and good luck with your search.
Thanks.
Now, as you can see from this video, this housing presenter was very rude, and she even rolled her eyes and said, you know, I think somewhere else is better for you. Again, an applicant has the right to live wherever they want. They can live on the first floor, second floor, and this also goes to the terms and conditions. The children should not be limited from going to the pool or limited to using the services of that property. So this is, again, another form of discrimination based on familiar status. When we think about housing discrimination, it's also important for us to think about the more subtle ways people learn about housing availability. The Act prohibits the making, printing, and publishing or cause to be published any notice, statement that indicates a preference or a limitation. This also applies to written materials, oral notices, or statements. It includes applications, brochures, deeds, signs, banners, posters, and billboards. Expressing to anyone a preference or limitation on a purchase is prohibited. For example, a newspaper advertisement states, "Beautiful 3-bedroom home for rent, no children allowed." This statement would be a violation of the Act. So at this point, we're going to have another poll for you all to do, and this is based on what protected group does the Office of Human Rights receive the highest number of complaints in the area of housing. So if you all can just take a quick moment to put what you think is the most highly complained about protected group, and then we'll show you the results from that. Okay, so we'll give a few more seconds. Okay, I'm going to close out the poll here. Aha! So most of you all picked race as one of the highly complained about protected categories. And I would have to say that in most instances you would be correct, but for the D.C. Office of Human Rights, our leading category is disability, and race comes in second. At one point, race was first, but now with the accessibility issues, disability has been our leading complaint base. Thank you for taking that poll. The Fair Housing Act doesn't just tell us what housing providers can't do, it also tells us what housing providers must do, like provide reasonable accommodations or reasonable modifications for persons with disabilities. Reasonable accommodations in housing applies to persons identified as having a disability or associated with someone who has a disability. And for instance, the association could be that you don't have the disability, but your spouse or your child or a friend who comes over or a parent who comes may have a disability. Reasonable accommodations are given to residents or applicants seeking housing to allow them an opportunity to fully enjoy the premises just as anyone else who does not have a disability. A reasonable accommodation is a change in the rules and procedures, but it should not fundamentally change how a housing provider operates. For example, the tenant requests a handicapped parking space because they have problems walking a far distance due to their disability. This is a reasonable request for the tenant to make to the landlord. However, if the tenant asks the landlord to bring him or her the daily newspaper because they're unable to walk a far distance, this would change the fundamental operation of the housing provider, unless this is some type of service that the housing provider provides to all tenants. Otherwise, this would not be considered a reasonable accommodation to have your paper delivered to your door. The tenant usually pays for an accommodation requiring modifications or structure of their home, such as the installation of a wheelchair ramp, unless the housing provider is federally funded, in which case the housing provider may pay for all of the modifications. It is the tenant's responsibility to make a reasonable accommodation request to the housing provider, either verbally or in writing. It is not for the housing provider to assume or guess or think that you require a reasonable accommodation. Even when they see a person in a wheelchair, they shouldn't automatically assume that this person will need some type of accommodation. At this point, we're going to talk about the modifications and making the request and what's needed. When the tenant is making a request, they should at least present some type of medical documentation. However, the landlord is not allowed to get into the nature and the details of your disability, only that you provide something from either a therapist or a medical assistant showing that you do have a certifiable disability. You can make a reasonable accommodation request, but they cannot inquire into the nature of your disability. In the accessibility of housing, apartments or homes built after March 13, 1991, they're required to at least have 7 technical accessible features. For one, accessible entrance on an accessible route, accessible common and public areas, usable doors, accessible route within the unit, accessible light switches, electrical outlets, and environmental controls such as your air condition switch or your heat switch, reinforced walls in the bathrooms, and usable kitchens and bathrooms. Here's a list of the type of properties that are covered under the Federal Fair Housing Act and the Human Rights Act. As you can see from the list, there are quite a bit of properties that are covered: apartments, single-family homes, condominiums, cooperatives. As you can also see, even vacant land zone for residential housing is covered. Now let's talk about the properties that are not covered under the Federal Fair Housing Act. The following 4 types of properties are not subjected to the rules of the Federal Fair Housing Act or the D.C. Human Rights Act. If someone was to bring a claim against these type of properties, it will more than likely be dismissed for lack of jurisdiction. So let's start with small property owners. Small property owners considered exempt if they do not have an interest in more than 3 single-family homes, they do not use the service of a broker or sales agent, and the building has 4 or fewer units and the owner resides in one of those units. So if you have an apartment building with a 4-unit building and the landlord lives there, more than likely that property is exempt from housing. However, as we talked about earlier, that property is not exempt from discriminatory advertising. So if they made a discriminatory advertisement, you found the ad in the newspaper and you saw it says no children, or it says, no blacks, things of that nature, that landlord would lose out on their exemption by making that discriminatory advertisement. Religious organizations. Religious organizations can give preference to members of their own religion or clubs in housing that they operate on a non-commercial basis. Groups and clubs, however, cannot restrict membership on the basis of race, color, or national origin. We're going to talk a little bit about senior housing. Senior housing is also considered exempt from the familiar status protection if, 1, all residents in the housing are 62 years of age or older, or at least 80% of the units are occupied by at least one person that is 55 years of age or older. Again, this only exempts people from filing familiar status protection. Now we're going to talk a little bit about the roommate situations. There is a caveat in the Fair Housing Act and in the D.C. Human Rights Act in which a person can have a preference or limitation in terms of roommate status. So, for instance, although a small property owner could be exempt, in this situation, if you have a shared living space and it's a female wanting another female, there is an exception to the rule for that. And it only applies to shared living situations such as sharing the kitchen and the bathroom. Okay, and so now this brings me to, I'm going to conclude by sharing some new information about the Fair Housing Act that was released from the Department of Housing and Urban Development only about a year ago. It's the HUD LGBT rule. The HUD LGBT rule became effective March 21st, 2012. This rule provides equal access to housing and HUD programs regardless of sexual orientation or gender identity. If the person is applying for a program that is federally funded, the agent should not inquire to the sexual orientation or the gender identity of a person to determine if they are eligible for a program. So that's pretty exciting. That's something new that HUD has opened up. And hopefully, with this new rule, this will also get HUD to add a new protected category maybe in the future. The bottom line is, the rule of thumb is that everyone should be treated the same based on their qualifications regardless of their protected class. That's the only thing that matters. It shouldn't matter about your race, your sex, your national origin, but that you're just as qualified as the next person. Everyone should have equal enjoyment to equal and safe, decent housing. Now, I would like for you all to take one more poll. We're going to collect this information, but I would like to let you know that this information is collected for a statistic purpose, is not going to be used with anyone. Based on the fair housing information provided today, please select one or more of the following as it pertains to housing discrimination. One is, I have been a victim, I know a victim, I have not been a victim, or I do not know a victim of housing discrimination. So we'll take a few minutes to answer this last poll. Very close. Okay. We'll take a look at the results. Wow. So we have at least 56% who know of a victim. And in the second category, some who said they have not been a victim. And so as we spoke about today, housing discrimination is very rampant. Some folks do not bring it to our attention. And so those of you out there who know of someone can lead them to our office and let them know that we have a process in which we will investigate complaints of discrimination. Because, again, everyone has the free range to live wherever they want, however they want, as long as they qualify, and it shouldn't be based on their protected category. Thank you so much for this, and at this time, we will take questions or comments if anyone has any.
And it looks like we do have a number of questions already sent to us through the chat feed. I can read some of those off, and perhaps Akita can answer them, hopefully. But like Akita said, please feel free to send any more questions you may have, although it looks like we have plenty to get us started with. One question I see here is, what about discrimination against people with pets?
Okay. Thank you, Elliot. That's a very good question. In housing situations, housing providers may have an apartment complex or a building in which they say no pets are allowed. However, if a person has a disability and they need the assistance of a service animals are not considered pets, and that is when an applicant can make a reasonable accommodation for a change in the rules to allow their service animal. And also, the landlord should not charge you because it is not a pet, it is a service animal, and you can make a reasonable accommodation request based on your disability for having a service animal. Thank you for that question. Do you have anything else, Elliot?
Yeah, I see another one here. With reference to the fewer than 4 exemption, which I'm assuming means 4 units in an apartment building, you're exempt. You mentioned you're exempt from the Federal Fair Housing Act if you have fewer than 4 places in your apartment or units in your apartment. Suppose an investor owns more than 4 properties through limited liability companies, each owned by a separate LLC. If the ad is not discriminatory, but the rental practices are, does the exemption apply?
It is possible that we may have jurisdiction over that respondent or that housing provider, because again what happens is there's certain exemptions or certain criteria that housing provider has to meet in order to claim the exemption. So if they have more properties, then that may take them out of the exemption. So even though the advertisement may have not been discriminatory, but if it shows that they have more than the required number of properties, then they could possibly have a complaint filed against them.
Excellent. Thanks, Akita. Another question that came in earlier is the owner of a senior housing building required to install grab bars in the tub or shower area in the bathrooms as well?
Yes. If that owner of the senior housing building, especially if it's a federally funded property, then yes, the housing provider should pay for the installation of the grab bars. Now, if it's a private landlord in which they don't receive federal funding, then more than likely that would be the responsibility of the tenant to pay for it. And they can even ask the housing provider to install it for them at their own expense, at the applicant's own expense or the resident's own expense. Some housing providers sometimes will make an agreement with that tenant. If they have it, installed, they reimburse them. And then sometimes they'll reach a happy medium, such as, like, say, for instance, it's a ramp to be installed at the building. That ramp would not only serve purpose for that one tenant, but it would serve purpose for other tenants and visitors that come to the building. So instead of having the tenant pay for it, the landlord may decide to negotiate and go in half. But more than likely, again, modifications are at the expense of the tenant or the landlord. Unless that property is federally funded, it is the responsibility of the landlord to pay for it.
Well, and I think you actually just answered the next question on the list here, which was when you say the landlord may pay, what factors determine the landlord's responsibility to pay? Do you have anything to add to that, or I think you mostly covered in the last?
Yes.
Yes. Okay. So another one we have here is Section 8 vouchers, which are the housing vouchers. We talked about that the D.C. Human Rights Act, unlike the Federal Fair Housing Act, does ban discrimination based on source of income. So the question we received is, do all apartments have to take Section 8 vouchers in D.C.?
Yes. Section 8 vouchers is a source of income, and it is protected under the Human Rights Act, and all landlords do have to accept it. However, if it's one of those landlords that we talked about earlier that is exempt from the Act, it may be possible that they do not have to accept it, but all major landlords, the big apartment complexes and so forth, they should be accepting the voucher.
Thank you. Another question that came in, it's a longer one, is the person says that they are actually a tenant and the property manager in their building is telling them that they can't try to negotiate, that the person who wrote the question can't try to negotiate a lower rent with her because if she agrees to the lower rent, she'd be violating fair housing laws. Is that true? And what if she lowers my rent, the person's rent, because she's a good tenant?
Okay. So, Elliot, I would have to say for that person, I can't give a concrete answer for that right now without looking into the details of their lease and their housing provider. So that would have to be a question in which we would need to get the person's name and information and look into that further. And then we also work with the Office of the Tenant Advocate. They're really good about telling tenants about their landlord-tenant rights. So that would be a question that I would have to look more into without giving an answer on the surface.
Okay. Another one here, and if you guys have any more questions, please feel free to send them in. But someone mentioned predatory lending here, and they said, what about predatory lending? And if you could describe that a little bit for us, Akita, that'd be great. And then the question is, can OHR take a case against a bank?
Yes. So financing and obtaining a loan, that is covered under the Human Rights Act and the Federal Fair Housing Act. So, for instance, if someone is trying to obtain a loan to buy a new home or to have the home rehabbed or to do some refinancing on the home or even for obtaining insurance, if you feel like you've been discriminated against, the person can file a complaint based on lending, a refusal to negotiate in the lending terms of loan, or even if the person receives a loan, but they feel as though this loan may be predatory, meaning that the bank has hiked up the prices and the points of that person's loan in comparison to a protected category. That person can file the discrimination complaint in lending based on the terms of their loans that may be significantly different than someone else who comes in and get a loan at a lower price, but they have the same qualifications.
So we're going to keep taking questions, and we still have some more in here, but we're just gonna put the contact information for us on the screen so that those of you who want to see it can see it. But the next question is actually a two-part question. I think that perhaps, Akita, if you want to answer the first part, I think I could probably answer the second. The question is, how hard is it to prove discrimination? And the second question attached to it is, does OHR find discrimination most times or in a very small percentage of the time?
Okay, that's a good question, Elliot. How hard or easy is it to prove discrimination? I would say that it's not necessarily difficult to prove discrimination, although if the person doesn't have certain information or if we don't have certain information, it could lead to be a difficult thing. But if a person believes or has information that they've been treated differently than others, all sources of information is a good start. So whatever the person has, even if they think, oh, this is not enough, they should still bring it to our attention because it may just be enough to prove their case. It also depends on the details and the nature of the case and the complexity of the case. So we would have to look at each case on a case-by-case basis. I can't say that one is harder than the other.
Okay, and then I'll take a stab at the second part, which again is about how often does OHR find discrimination. The answer to that is actually perhaps a little more complex than it seems at first. We mentioned earlier that we have mandatory mediation at OHR, which means that whoever made the complaint, we bring them into our office along with the person who the complaint is against and make them sit down with one of our expert mediators to try and find a mutual agreement. So 41% of our cases last year ended at this mediation stage, meaning that the two parties came to an agreement, which is excellent. Mm-hmm. It makes the process easier for them. Theoretically, because they came to agreement, they found mutually beneficial results. And because of that, we really try to encourage people to settle in mediation. So on the face of it, 41% of our cases, again, are solved at that stage. Of the 59% that are left over, the amount that we find probable cause on varies, but it usually is around 15% or so we find probable cause. So we like to think of it as about 50% of our cases, either an agreement is made or probable cause is found. So actually a high number of our complainants get some sort of resolution. Mm-hmm. The next person, or the next question here, is what if I file a complaint and get evicted or threatened because I filed?
Mm-hmm. So in situations like that, if you file a complaint, which is considered a protected activity, a person can file a retaliation claim with our office if they believe that they've been retaliated against or either harassed or coerced because they have participated in a protected activity, such as exercising your rights under the Fair Housing Act or the D.C. Human Rights Act, or, filing a complaint, or even if a person is participating in a complaint, they didn't file the complaint directly, but they assisted someone in participating in a complaint and filing their own complaint, they are protected by the retaliation laws of the Human Rights Act and the Federal Fair Housing Act. They can come in and file a retaliation complaint with our office.
Okay, next question here is, are condo owners who rent their units exempt?
It's possible that condo owners who rent their unit could be exempt. It depends on the number of houses or homes that they own. So if they own more than one condo unit in the district, in the D.C. area, the D.C., Maryland, Virginia area, it could be possible that that would bring them under the exemption, and sometimes they may not, depending on how many units or properties that they own. So if it's a condo owner who's renting out their unit, just their unit in the building, they may be exempt under the Act. But if that condo owner has like another property, a single-family home, and then maybe 2 other apartments somewhere else, then they may not be exempt from the Act. So we would have to look at that more closely and basically do a property search to see what other properties that person owns.
Okay. So the next question I'm not even sure of the answer to, which makes me really glad Akita is here. In a sublet housing accommodation, so in a sublet where discrimination has occurred, who is responsible? Would it be the landlord or the subleaser that is acting as the housing provider?
It could possibly be both, because it depends on what it is, what the action is that was taken, or what the issue was itself. And now if someone decides to sublet their unit, and in some apartment buildings that's illegal to sublet your unit, and you may have to get special permission, so there may be some liability on the owner itself that sublet the apartment, or it could be some liability on the overall landlord, depending on the issues. And that's something that we probably have to take a closer look at and find out what type of property is and what the issue is itself.
All right, and the next question I think I can answer here, it asks about the statute of limitations concerning discrimination cases. The statute of limitations is 1 year in housing, employment, public accommodations, and educational institutions. The only real exception to that rule is in employment. If you're a D.C. government employee, you only have 6 months from the last incident to file with the Office of Human Rights. But otherwise, for all of our protected categories and areas, it's 1 year.
Right. And, Elliot, I will add that for housing cases, it's 1 year for our office at the Office of Human Rights, but you can also file in court. In court, you have up to 2 years to file.
Thanks, Akita. So we have one more question. Anyone that has additional questions, get them in soon so we can be sure to answer them for you. The last question is, does it take too long for OHR to render does it take too long for OHR to render a decision? In court, it's very long.
For OHR for housing complaints, under the HUD statute and the HUD regulations, housing complaints must be investigated within 100 days. However, our great director, Gustavo Velasquez, has mandated that we investigate housing complaints within 90 days, and for the most part, we have been keeping with that guideline. So for the investigators, from the beginning to the end, from the initiation of the complaint to the end, we've been able to investigate and complete housing cases within 90 days, and a lot of times much sooner than 90 days, especially when the case goes through mediation. It could be settled in 30 to 45 days.
Okay, excellent. Okay, we did get 2 more questions, and then after that we're probably going to have to cut it off in respect for your time. We'll wrap it up and mention one more thing. So the last 2 questions are, how does someone show proof of discrimination?
Okay. Well, that's a good question. Again, it depends on the type of case. So let's just say that it's a rental case. The applicant wants to rent an apartment, and they believe that they did not get the apartment based on their disability. because when they came in either on crutches or they came in a wheelchair. And they came in and inquired about the apartment, and the person was told that there's no apartments available. However, that person may have waited around and saw that another applicant comes in, and they tell them, oh, sure, yes, there's 2 apartments available. So you may not know right offhand, but then you may think, oh, maybe it's because of my disability that they told me that the apartments were not available. So one of the things that you could do is just observe your surroundings, gather the material information that you received at the property, maybe even ask that person, for their name or how they found out about the apartment so that you can share that with our intake officer. But the office itself has our ways and mechanisms and methods of investigating those complaints and proving whether or not discrimination has occurred.
Excellent. The last question is, what type of damages can a person or family that has experienced discrimination seek in court?
Okay. So with our office, I can only speak about our office. A person can recoup, for instance, say a person is looking for an apartment, they didn't get the apartment they wanted, they had to go across town to get another apartment. They can recoup the difference between that apartment and the new apartment that they bought. They can also maybe recoup the time that they spent searching for a new apartment. They can hopefully keep their receipts and everything that they've spent, the application fee. So if they put an application fee in the apartment or a deposit on their apartment and they didn't get it and they believe it was a discriminatory reason, they can recoup the deposit from that. So they can get monetary damages. And then also, in some cases with us, we would also look at the psychological and emotional damage, how the housing discrimination has affected them. Even with the psychological and emotional damage, you can't put a price tag on that, but there are some measures to try to look at, did you wake up in a cold sweat at night? Did you tell a lot of people about it? Did you find yourself crying? So there is some sort of tangible reference that we could put onto that. But you can recoup monetary damages as well as some punitive damages.
Excellent. Well, thank you very much, Akita, for sharing your expertise with us and for you all for joining us. I believe our wonderful event administrator is going to be putting a survey up for you all, and you can also download our presentation pretty soon. I think they're going to put it up on the screen. And if you have any other questions, please feel free to get in contact with Akita, and we'd be happy to answer those questions for you.
Yeah. Thank you,
so
Elliot.
much for attending.
Thank you all for attending. Have a great evening.